Greetings. I hope that this video finds you and your loved ones in the best of health and in good cheer amid these lamentable times brought about by the coronavirus pandemic. This video will discuss the provisions of the revised rules on criminal procedure with respect to the quashal of a complaint or information under Rule 117 thereof, as well as the applicable jurisprudence on the stated subject matter. This is created for the benefit of my second year JMC College of Law students to supplement our discussion on the rules on criminal procedure. Now, before we proceed, however, it must be underscored that this is merely a review, and consequently, the discussions herein are not comprehensive. And with that, we begin. As was stated earlier, the particular topic that would be discussed in this video is the concept of a motion to quash, or the quashal of a complaint or information under Rule 117 of the revised rules on criminal procedure. At the outset, it would be perhaps prudent to first define a motion to quash. What is a motion to quash? How do we define a motion to quash? In the case of People versus Cadabis, 97, Philippines CRA, 829, People versus Ferrer, 101, Philippines, 234, and People versus Navarro et al., 75, Philippines, 576. The Supreme Court had the opportunity to define a motion to quash as a motion filed by the accused seeking the dismissal of the information before entering his plea, wherein he hypothetically admits the facts alleged in the information and no facts contrary to those alleged or facts which do not appear on the face thereof can be considered by the court in resolving it. Likewise, in People of the Philippines versus Edgardo V. Odtuhan, GR number 191566, July 17, 2013, the Supreme Court held that a motion to quash the information is the mode by which an accused assails the validity of a complaint or information filed against them for insufficiency on its face in the point of law, or for defects which are apparent in the face of the information. It is the hypothetical admission of the facts alleged in the information. The fundamental test in determining the sufficiency of the material averments in an information is whether or not the facts, as alleged therein, which are hypothetically admitted, would establish the essential elements of the crime defined by law. Evidence aliunde, or matters extrinsic of the information, are not to be considered as a general rule. To be sure, a motion to quash should be based on a defect in the information, which is evident on its face. Take note that the defect in the information is evident on its face as a general rule. Now, equally important to avoid any confusion is the definition of the term to quash as it relates to our present subject matter. To quash basically means to annul, vacate, or overthrow. Now let's proceed to its nature. What is the nature of a motion to quash an information or a complaint? A motion to quash a criminal complaint or information is in the nature of a litigated motion, okay, and an omnibus motion. We shall discuss the ramifications of its nature as we proceed with the latter parts of this discussion. Now, question. Is a motion to quash a complaint or information allowed under the rules on summary procedure? Pertinent to this discussion is Section 19 of the revised rules on summary procedure, which states that the following pleadings, motions, or petitions shall not be allowed in the cases governed by the rules. Letter A, motion to dismiss the complaint or to quash the complaint or information, except on the ground of lack of jurisdiction over the subject matter or failure to comply with the preceding section. Now, as a general rule, a motion to quash a complaint or information is a prohibited motion, except lack of jurisdiction over the subject matter. Again, on those cases, criminal cases, where it is covered by the rules and summary procedure. As a general rule, a motion to quash a complaint or information is a prohibited motion, except lack of jurisdiction over. Now let us proceed to the formal requirements or the formal requisites of the filing of a motion to quash. Firstly, let us discuss the prescriptive period of the filing of a motion to quash. When do you file this particular motion? Rule 117, Section 1 of the Revised Rules on Criminal Procedure provides that the time to move to quash may be made at any time before entering one's plea. The accused may move to quash the complaint or information. Now again, when do you file a motion to quash a complaint or information? It should be at any time before entering your plea. You, as the accused, may move to quash the complaint or information. Now, in relation thereto, emphasis should be made on the fact that a motion to quash is, by its nature, an omnibus motion. Now, what is an omnibus motion? An omnibus motion is a motion which attacks a pleading, judgment, order, or proceeding and must raise all available grounds for objection. Otherwise, it is deemed waived. This is provided under Rule 15, Section 8 of the Revised Rules of Court. Now, why is this important? When you file your motion to quash, you must include all your grounds therein. Those grounds which are not included in that motion to quash are deemed waived. You cannot raise it anymore. However, this is only the general rule. Okay? There are certain exceptions to this rule. Now, what are the exceptions to the omnibus motion rule? First is when the complaint or information does not charge an offense. Second, when the court lacks jurisdiction over the offense charge. Third, when there is extinction of the offense or penalty. And lastly, when there is double jeopardy. Okay? Again, any one of these four exceptions to the omnibus motion rule, the same can be raised or considered motu proprio by the court at any stage of the proceedings or on appeal. Again, if those exceptions were not raised before arraignment, they may still be raised. They are not waived because these are the exceptions to the omnibus motion rule. Now, what is the second formal requirement of a motion to quash? It must be in writing. A motion to quash, being a litigious motion, cannot be made orally. It must be made in writing, or it must be in writing. Third formal requirement, it should be signed by the accused or his counsel. And lastly, it shall distinctly specify its factual and legal grounds. Now let us proceed to the grounds of a motion to quash a complaint or information. What are the grounds of a motion to quash a complaint or information? This is answered by Section 3, Rule 117 of the Revised Rules on Criminal Procedure, which provides that the accused may move to quash the complaint or information on any of the following grounds. First, that the facts charged do not constitute an offense. Second, that the court trying the case has no jurisdiction over the offense charged. Third, that the court trying the case has no jurisdiction over the person of the accused. Fourth, that the officer who filed the information had no authority to do so. Fifth, that it does not conform substantially to the prescribed form. Next, that more than one offense is charged, except when a single punishment for various offenses is prescribed by law. Another ground is that the criminal action or liability has been extinguished. Another ground, that it contains averment, which if true, would constitute a legal excuse or justification. And lastly, that the accused has been previously convicted or acquitted of the offense charged, or that the case against him was dismissed or otherwise terminated without his express consent. This is the concept of double jeopardy. Now let us discuss these grounds in detail. Okay, let us proceed to the first ground. Alright, before we proceed with the grounds for a motion to quash, before I forget, it must be emphasized that matters aliunde, or those not stated, not alleged in the complaint or information, shall not be considered in the determination of whether or not to grant or deny the motion to quash. Precisely, in the case of Cruz versus Court of Appeals, 194 SCRA 145 1991, the Supreme Court categorically held that only facts alleged in the complaint or information shall be considered in a motion to quash. Again, as a general rule, only facts alleged in the complaint or information shall be considered in a motion to quash. Precisely, if there are matters of defense, they cannot be considered. Now, that is the general rule. There is an exception to this rule. Okay, when the ground for a motion to quash is prescription, extinction of criminal liability, and double jeopardy, extrinsic facts, or those matters aliunde, or those matters not alleged in the complaint or information may be considered in the determination of whether or not the motion to quash will be granted or denied. All right? And with that, we proceed with the grounds. The grounds for a motion to quash. All right, let's go to the first ground. What is the first ground? That the facts charged do not constitute an offense. Now, in People versus Supnat, the Supreme Court held that to determine whether the facts charged constitute an offense is whether or not the facts so alleged, if hypothetically admitted to be true, would constitute the elements of the offense charged. Precisely, if the answer is in the negative, the ground for the quashal of the complaint or information will be sufficient to sustain the motion. In relation thereto, in Rodolfo Valencia versus Sandigan Bayan et al., GR number 141336, June 29, 2004, and Garcia versus Court of Appeals, GR number 119063, January 27, 1997, and Inco et al. Versus Sandigan Bayan, GR number 112584, May 23, 1997, the Supreme Court held that the fundamental test in reflecting on the viability of a motion to quash under this particular ground is whether or not the facts asservated, if hypothetically admit, would establish the essential elements of the crime defined in the law. In this examination, again, as a general rule, matters aliunde are not considered. However, by way of exception, inquiry into facts outside the information may be allowed, where the prosecution does not object to the presentation thereof. Right. Again, what is the test in determining the viability of the motion to quash on the ground of the facts charged do not constitute an offense? Again, the fundamental test in reflecting on the viability of a motion to quash under this particular ground is whether or not the facts asseverated, if hypothetically admitted, would establish the essential elements of the crime defined by law. You only have to consider the facts as alleged in the complaint or information. And as such, as a general rule, matters aliunde, or those matters which have not been stated in the complaint or information, should not be considered. All right, let's go to the second ground. What is the second ground of a motion to quash? The second ground for a motion to quash is that the court trying the case has no jurisdiction over the offense charge. This jurisdiction over the offense charge, we have already discussed this previously when our topic was on jurisdiction of the court in criminal cases, jurisdiction over the offense charge. And again, by way of review, how is it determined? It's determined by the allegations, the complaint, and information. How is jurisdiction over the offense charge conferred? It is conferred by law. Now, again, by way of review, what is the significance when we say the jurisdiction over the offense charge is conferred by law? Okay, the ramifications of this is that the jurisdiction over the offense charge cannot be waived, cannot be subject to the whims of the parties, cannot be subject to the agreement of the parties. Okay, and as such, this is one of the exceptions to the omnibus motion rule. Okay, this is one of the exceptions to the omnibus motion rule, and as such, jurisdiction questions as to jurisdiction over the offense charge may be raised even after you have entered your plea or the accused has entered his plea, even on the first time on appeal, because it is conferred by law. It cannot be waived as a general rule. Okay? Now, in determining whether or not the court trying the case has jurisdiction over the offense charge, again, generally, you consult only the facts alleged in the complaint or information. Okay? Right, that's clear. Now, let's proceed to the third ground. What is the third ground of a motion to quash or the quashal of an information? The third ground states that the court trying the case has no jurisdiction. Only this time, the court has no jurisdiction over the person of the accused. Now, by way of review, how does the court acquire jurisdiction over the person of the accused? Again, it is upon his voluntary surrender, upon the arrest of the accused, or upon the appearance of the accused for purposes of arraignment. It must also be underscored that jurisdiction over the person of the accused, once acquired by the court in criminal cases, is retained until the termination of the case. All right, that's clear. Let's go to the fourth ground, that the officer who filed the information had no authority to do so. Again, by way of review, who are the officers authorized by law to sign the information? First is the provincial and city prosecutors as provided in Rule 112, Section 4. The ombudsman or the deputies in cases involving criminal cases that fall within the jurisdiction of the Sandigan Bayan, or those criminal cases involving public officers in the exercise of their official functions. Who else? Who else are the officers authorized by law to sign the information? A special counsel appointed by the Secretary of Justice to assist the city prosecutor, as provided in Acer versus Perez, 49 SCRA 508, and in People versus Henderson III, et al., 105 Philippines 859. And also, in election cases or in cases properly within the jurisdiction of the COMELEC, the officers of the COMELEC is authorized by law to sign the information, as provided in the case of People versus Inting, 187 SCRA 788. It must also be emphasized that the officer signing the information must have authority to do so. Otherwise, the court has no jurisdiction. Okay, now what is the effect of this? The defect of the lack of authority of the officer signing the information cannot be cured. Okay, class A? The defect cannot be cured. Precisely, an amendment of a complaint or information will not cure the defect when the officer signing it has no authority to do so. The information is void if the officer has no authority to sign the information. Again, amendment of the complaint or information will not cure the defect. Okay? Also, as provided in the case of Cruz versus Sandigan Bayan, 194 SCRA 474, an information signed by the prosecutor after his retirement is void. Why? Because he has no more power to do so. Just like a judge who signed a decision after his retirement. All right, let's proceed with the fifth ground. What is the fifth ground of a motion to quash? Fifth ground states that the complaint or information does not conform substantially to the prescribed form. Now, by way of review, what should a complaint or information contain in order for it to be sufficient? All right? Now, under Rule 110, a complaint or information is sufficient if it states the first name and surname of the accused or any appellation or nickname by which he is known or had been known. Now, when the offense is committed by more than one person, all of them shall be included in the complaint or information. Second, the designation of the offense given by statute. Third, the acts or omissions complained of as constituting the offense. Fourth, the name of the offended party. Fifth, the approximate date of the commission of the offense. And lastly, the place where the offense was committed. Now, class, you have to remember that when the complaint or information does not conform substantially to the prescribed form, or the 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 matters that I have just mentioned were not included, or that it was stated vaguely in the complaint or information, the accused has two options: either to file a bill of particulars, okay, in order to clarify the vagueness of the matter stated or the facts alleged in the complaint or information, or a motion to quash on the basis of the fifth ground, that the complaint or information, the facts stated in the complaint or information, does not conform substantially to the prescribed form. Now, what are the options of the judge in this case? He may order the amendment of the complaint or information, or the quashal thereof. All right? Let's proceed to the sixth ground. Okay? That more than one offense is charged, except when a single punishment for various offenses is prescribed by law. Now, what is being talked about here? Okay? This is the duplicity or multiplicity of charges in the complaint or information. Now, what is the reason for this particular ground of a motion to quash? Okay, what is its purpose? Okay, in People versus Magnampo, 99 Philippines, 967, duplicity or multiplicity of charges is in a single information is prohibited precisely to protect the accused from confusion and difficulty in making his defense. Okay? Of course, splitting of one offense into various charges is a form of harassment. Okay? However, there is an exception to this rule, and that exception is the complex crime under the revised penal code, particularly Article 48. Okay? That is the exception to the rule na pwede daghan na crime na ibutang nimo sa complaint or information. However, as a general rule, one crime, one offense, one complaint, single complaint, or information. Okay? By way of exception, Article 48, which refers to complex crime. Right? Let's proceed to the seventh ground. What is the seventh ground? The motion to quash. That the criminal action or liability has already been extinguished. Okay, this ground is related to the provisions of your Criminal Law 2 or Criminal Law 1. No, Criminal Law 1. Okay, I apologize. Your discussions in Criminal Law 1, extinguishment of criminal liability. So you already know this. Right? Let's just browse through here. Okay? You must remember that amnesty extinguishes totally the liability and the criminal action. It completely extinguishes the penalty and all its effects. Okay? Likewise, the absolute pardon, okay, removes all disabilities resulting from the conviction. Okay? However, it must be emphasized that one of the causes of criminal extinction of criminal liability is the death of the accused or the death of the offender. Precisely, if the accused is already dead, how can he have criminal liability? Okay, mapriso ba daw ng patay na? Okay, so death extinguishes criminal liability only as to himself. Klasa, the death of one of the accused extinguishes criminal liability as a general rule only as to himself. Okay? Indeed, the death of one or several accused is not a cause for the dismissal of the criminal action. Okay? If there are other accused, okay, the criminal liability of the deceased is extinguished, but not the criminal liability of the survivor or survivors. Okay? The accused to survive. Hence, the prosecution of the case would continue and would not be suspended. Okay? Again, the death of the offended party, whether in the private crime or in a crime which is against the state, will not abate the prosecution of the case. Okay, class? Let us review as to the death. Okay? If the offended party dies, it does not affect generally it does not affect the criminal liability of the offender. If the offender of the accused dies, criminal liability with regards to himself is extinguished. However, the criminal liability as a general rule as to the other accused will not be extinguished. Okay? Now let's proceed to the eighth ground. What is the eighth ground for a motion to quash? That the complaint or information contains averments which, if true, would constitute a legal excuse or justification. Alright, let's proceed to the eighth ground. That the complaint or information contains averments which, if true, would constitute a legal excuse or justification. Take note, class, it is the complaint or information which contains the allegations. Okay? The allegations which, if true, would constitute a legal excuse or justification. Not the counter affidavit, not the defense. The complaint or information itself contains averments which, if true, would constitute a legal excuse or justification. Now, what is being talked about here? Okay? It is the justifying circumstances under Article 11, paragraph under Article 11 of the Revised Penal Code, exempting circumstances under Article 12 of the Revised Penal Code, and also accessories exempt from criminal liability under Article 20 of the Revised Penal Code. To refresh your memory, kay kaning Article 11 justifying circumstances and Article 12 exempting circumstances, memorize na ba ninyo? Kaning accessories, basig makalimot mo. Kaning accessories exempt from criminal liability under Article 20 of the RPC. Let us review. Okay? Kaya basig nakalimtan na ninyo ni. Kaning Article 20. As provided in Article 20 of the Revised Penal Code, the accessories exempt from criminal liability provides the penalties prescribed for accessories shall not be imposed upon those who are such with respect to their spouses, ascendants, descendants, legitimate, natural, and adopted brothers and sisters or relatives by affinity within the same degrees, with a single exception of accessories falling within the provisions of paragraph 1 of the next preceding. Alright, let's proceed to the ninth ground for motion to quash. The ninth ground provides that the accused has been previously convicted or acquitted of the offense charged, or the case against him was dismissed or otherwise terminated without his express consent. Now, what is being talked about here? What is being described here? Is the rule on or the concept of double jeopardy. Now, before we proceed any further, let us first discuss the legal basis for the prohibition on double jeopardy. Now, double jeopardy, the concept of double jeopardy receives its basis from the Constitution itself, particularly Section 21, Article 3 of the Constitution of the Philippines, which provides that no person shall be twice put in jeopardy of punishment for the same offense. If an act is punished by a law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. Apropos thereto, Rule 117, Section 7 of the Rules of Court expressly provides that when an accused has been convicted or acquitted, or the case against him dismissed or otherwise terminated without his express consent by a court of competent jurisdiction upon a valid complaint or information or other formal charge sufficient in form and substance to sustain a conviction, and after the accused has pleaded to the charge, the conviction or acquittal of the accused or the dismissal of the case shall be a bar to another prosecution for the offense charged, or for any attempt to commit the same or frustration thereof, or for any offense which necessarily includes or is necessarily included in the offense charged in the former complaint or information. Now, from that provision, we can determine the elements of double jeopardy. Okay? Precisely as provided in the case of Saturnino C. Ocampo versus the Honorable Ephraim S. Abando et al., GR number 176830, February 11, 2014. The Supreme Court had the opportunity to discuss and enumerate the elements of double jeopardy. Precisely, the Supreme Court held in that case that double jeopardy only applies when, first, a first jeopardy has attached. Second, it has been validly terminated. And third, a second jeopardy is for the same offense as in the first. A first jeopardy attaches only after the accused has been convicted or acquitted, or the case has been dismissed or otherwise terminated without his express consent by a competent court in a valid indictment for which the accused has entered a valid plea during arraignment. Alright, to reiterate, double jeopardy attaches if the following elements are present. Okay, double jeopardy attaches if the following elements are present. First, there is a valid complaint or information. Second, it is before a court of competent jurisdiction. Third, the defendant had pleaded to the charge and the first jeopardy was validly terminated. How? The defendant was acquitted, okay, or the defendant or accused was convicted of the case against him, okay, or the case against him was dismissed or otherwise terminated without his express consent. However, it must be noted that jurisprudence allows for certain exceptions when the dismissal is considered as final and therefore the first jeopardy has been terminated even if it was made on motion of the accused. So this is the exception to the general rule that the dismissal was without the consent of the accused, because the dismissal in these exceptional cases was upon the motion of the accused. Now, what are these exceptions? The first would be where the dismissal is based on a demurrer to evidence filed by the accused after the prosecution has rested, which has the effect of a judgment on the merits and operates as an acquittal. So, if the criminal case was dismissed because of a demurrer to evidence filed by the accused, it qualifies as a valid termination of the first jeopardy. Okay? And second, the second exception where the dismissal is made also on motion of the accused because of the denial of his right to speedy trial, which is in effect a failure to prosecute, as provided in the case of Bangayan Jr. versus Bangayan, GR number 17277, October 19, 2011. So, if the dismissal is based on the demurrer to evidence or the violation of the right to speedy trial of the accused, double jeopardy would apply. Okay? Now, question. Does double jeopardy apply in preliminary investigation cases or in the preliminary investigation stage? For example, if a case was filed, regular filing with the office of the prosecutor, the office of the city prosecutor or the office of the provincial prosecutor, if a complaint was filed there and the fiscal dismissed the case, would it constitute as double jeopardy, okay, to a subsequent case based on the same facts, based on the same offense? No, there would be no double jeopardy because the elements are not present. Precisely, there is still no valid indictment. There is no valid indictment before a competent court. There was no valid arraignment. There was no valid plea. Okay, so in that case, if the case was dismissed as against the respondent in a preliminary investigation stage, it does not constitute as double jeopardy to a subsequent case based on the same facts and on the same offense. Okay, in relation to our topic in double jeopardy, this was asked in the bar. I think it was in 2010. What is res judicata in prison gray? Okay, this is another term for double jeopardy again. Res judicata in prison gray is another term for double jeopardy. What case is this? This is the case of KS versus IAC or KS versus Intermediate Appellate Court 179, SCRA 5459. Okay? Again, double jeopardy is also coined as or termed as res judicata in prison gray. Okay. Now, question. What is the effect of double jeopardy on the civil aspect of the case class? civil aspect, not the criminal aspect, not the penal provision or penal consequences of the act, but as to the civil aspect. Katong ibayad nimo sa offended party. What is the effect of double jeopardy in that case? Okay? Now, in this case, the Supreme Court, in the case of Salazar versus People, 411 SCRA 598606, the Supreme Court had the opportunity to explain that while a judgment of acquittal cannot be appealed by the prosecution, either the offended party or the accused may appeal the civil aspect of the judgment despite the acquittal of the accused. Klasa, again, while a judgment of acquittal cannot be appealed by the prosecution, either the offended party or the accused may appeal the civil aspect of the judgment despite the acquittal of the accused. Okay? However, the public prosecutor cannot appeal the civil aspect of the decision because the public prosecutor is not the private offended party who suffered the damage. Okay? Alright? By way of review, Rule 117, Section 7 of the Rules of Criminal Procedure provides that the rule against double jeopardy precludes another prosecution for the offense charged, okay, for the same offense charged, for any attempt to commit the same, a frustration thereof, or for any offense which necessarily includes or is necessarily included in the offense charged. Again, as a rule, double jeopardy precludes another prosecution for the same offense charged, for any attempt to commit the same, frustration of the said offense, or for any offense which necessarily includes or is necessarily included in the offense charge. Okay? For example, a conviction for attempted murder or a conviction of frustrated murder will bar a subsequent prosecution for attempted murder of the same person. Okay? However, this is only the general rule. Okay? There are certain exceptions where the conviction of the accused shall not be a bar to another prosecution for an offense which necessarily includes the offense charged in the former complaint or information. Now, what are these exceptions? First, that the graver offense developed due to supervening facts arising from the same act or omission constituting the former charge. Second, the facts constituting the graver charge became known or were discovered only after a plea was entered in the former complaint or information, or the plea of guilty to a lesser offense was made of the prosecutor and of the offended party except as otherwise provided in Section 1F of Rule 116. For example, if the accused had been convicted of serious physical injuries, but after the conviction, the victim died as a result of the very same injuries for which the accused was convicted, can double jeopardy be raised as a defense? No, it cannot. It cannot be raised as a defense in a prosecution for a graver offense because of those that I just stated. Again, the graver offense, which in this case was death, which supervened, must have arisen out of the same act or omission constituting the former charge. So what is the graver offense here? The offense of homicide or murder because of the death. The supervening event was the death, okay, arising after the accused was already convicted of serious physical injuries. Namatay man paguman, okay? Can the conviction of serious physical injury be considered as a double jeopardy for the subsequent prosecution of homicide or murder? Can namatay? No, it cannot. It cannot because the graver offense developed due to supervening facts arising from the same act or omission constituting the former charge. Alright? With that, we have finished the grounds for the quash, the grounds for the quashal of the complaint or information. Now let us discuss the amendment of a complaint or information in relation to our subject of a motion to quash. Now, this is provided under Rule 117, Section 4 of the Revised Rules on Criminal Procedure, which expressly states that if the motion to quash is based on an alleged defect, of the complaint or information which can be cured by amendment, the court shall order that an amendment be made. If it is based on the ground that the facts charged do not constitute an offense, the prosecution shall be given by the court an opportunity to correct the defect by amendment. The motion shall be granted if the prosecution fails to make the amendment or the complaint or information still suffers from the same defect despite the amendment. Now, question: when is an amendment of a complaint or information allowed in the case of an alleged defect? It is allowed if the motion to quash is based on an alleged defect of the complaint or information which can be cured by amendment. The court shall order that an amendment be made. Okay. In correlation thereto, in People of the Philippines versus Edgardo V. Odtuhan, GR number 191566, July 17, 2013, the Supreme Court held, thus, if the defect can be cured by amendment, or if it is based on the ground that the facts charged do not constitute an offense, the prosecution is given by the court the opportunity to correct the defect by amendment. Now, if the motion to quash is sustained, the court may order that another complaint or information be filed, except when the information is quashed on the ground of extinction of criminal liability or double jeopardy. Now, in that case, no valid information can subsequently be filed based on the same facts and circumstances and based on the same offense. Okay? Now, let's proceed to the effect. What are the effects, or what is the effect of sustaining a motion to quash? This is provided in Rule 117, Section 5, the Revised Rules on Criminal Procedure, which states to it, if the motion to quash is sustained, the court may order that another complaint or information be filed, except as provided in Section 6 of this rule, as we have mentioned earlier. If the order is made, the accused, if in custody, shall not be discharged unless admitted to bail. If no order is made, or if having been made, no new information is filed within the time specified in the order, or within such further time as the court may allow for good cause, the accused, if in custody, shall be discharged, unless he is also in custody for another charge. Now, from that, we can discern what are the effects of sustaining a motion to quash. Now, again, what are these? If the motion to quash is sustained, the court may first order that another complaint or information be filed, except as provided in Section 6 of this rule. If the ground is quashed on the basis of ground of extinction of criminal liability or double jeopardy, no new information can be filed on the same offense and based on the same facts and circumstances. Now, second, what is the second effect if the motion to quash is sustained? Now, if the order is made, the accused, if in custody, shall not be discharged unless admitted to bail. Now, if there is no order made to that effect, or if having been made, no new information is filed within the time specified in the order, or within such further time as the court may allow for good cause, the accused, if in custody, shall be discharged unless he is also in custody for another charge. Okay? Now, question: what is your remedy in case of the denial of a motion to quash? What is your remedy? This is answered by the Supreme Court in the case of Yap and Vailoses versus the Honorable IAC, or the Honorable Intermediate Appellate Court et al. 220 SCRA 245, wherein the Honorable Supreme Court held that when a motion to quash a criminal case is denied, the remedy, as a general rule only, class, as a general rule, the remedy is not certiorari, but to go to trial without prejudice to reiterating the special defenses invoked in the said motion. In the event that an adverse decision is rendered after, on the merits, an appeal therefrom should be the next legal step. Okay? So what is your remedy when the motion to quash is denied? You proceed with a trial. You proceed with a trial, and if you are found guilty, and if the accused is found guilty, you raise it on appeal. You raise your issue on the motion to quash on appeal. So that is the remedy as a general rule. Certiorari will not lie. And with that, we conclude our review on the quashal of a complaint or information under Rule 117 of the Revised Rules on Criminal Procedure. Again, as this is merely a review, the discussion was not comprehensive and should only be treated as a supplementary aid to your reading. Thank you for giving your time to listen to the lecture, and it is my sincerest hope that the same has been informative and or at the very least helpful. Thank you.